Hi all, we're starting just a minute early. If you don't know, my name is Grace. I'm the operations manager for the Dyslexia Association of London, and I am with Chris White, who is a lawyer that we have worked with many times at the Dyslexia Association of London, and you might recognize him from our conference last year. So we're really grateful that he's taking an hour out of his day to speak with us about the law as well as take some of your questions. And I did get a couple questions in advance of this webinar, so I'm going to give first priority to those, of course, and then also we will leave the question and answer box open during the webinar. So if you have any questions, feel free to put your questions in there, and we're kind of going to stay on a first come, first serve basis, saving time for the questions I received via email, and also just whoever is able to put their questions in first, just due to time constraints. So other than that, I'm going to let Chris lead this webinar, and I will just be in the background, keeping an eye out on the chat box, and I'm going to just fade into the background. So without further ado, Chris, thank you so much for being here, and I will let you take over.
Thank you very much, Grace, and hopefully everyone can hear me okay. If you can't, just give me a shout or and I'll see if there's anything wrong with my microphone. Thank you, and welcome everybody to this presentation. As Grace mentioned, I've sort of done some work with Dyslexia London before, and this is a talk that I've given before as well. But I think it is really important because it highlights a lot of really important legal rights that are afforded to neurodiverse people, and in particular people with dyslexia. And I think are things that perhaps people might be aware of or not aware of at all, but definitely kind of understanding what that means for you as a person with dyslexia is really important, because I think it helps sort of frame, and we're going to focus particularly in this talk on sort of employment rights, but I think it can obviously expand a bit wider, and I'll touch on a bit of that as I go through the talk. And what I also want to kind of do towards the end is provide you some information about, so I'll obviously be talking about the legal rights that you have, and that sometimes can seem a bit abstract. But also obviously what is important is kind of like what you then do with that, and then how you use those rights in the context of kind of what is going on in your particular situation to enforce those rights if, in the unfortunate set of circumstances where somebody isn't giving you what you are entitled to under the law. So hopefully that's kind of.
Oh, Chris, I think you were muted. Oh, there you go.
Sorry.
No
Yeah.
worries.
Okay, so what are we going to cover? So the whole sort of framework around which we'll explore your rights as a person with dyslexia are under what's called the Equality Act, and I'll go into a bit more detail about what the Equality Act is, and it may be that people have an understanding of that already. But I'll give a bit of a sort of an overview of what that is, and then how that plays into kind of being a neurodiverse person and a person with dyslexia in the workplace. And that's going to be kind of like the core focus, as I mentioned. Somebody's got their hand up. It's Luca. So let me just. I'm happy to take questions as we go. By the way, I appreciate that we've got plenty of time, so I'm just gonna.
I think if you can speak a bit louder,
Okay, can people hear me now?
Yeah, other people are saying that it's
Sorry, I
okay.
can't hear what you're saying.
You can't hear
It's
anything
fine.
that I'm
That's
saying.
just gone.
Okay, let me just see if I can.
Other people are saying they can hear you okay, so maybe it might
Okay.
just be a problem with your phone. You might want to try joining on a laptop as
It's
well.
showing
That
as
might.
mute. Oh, sorry, it's my phone.
Okay.
No worries.
I'm so sorry about that.
No worries.
Um, well, yeah, and if anybody does have any issues hearing me at any point, just please do shout. Um, so yes, we're going to talk about neurodiversity and dyslexia in the workplace in the context of the Equality Act and the sorts of things that can assist you uh, in relation to that, particularly things like reasonable adjustments and what you can do if you're being discriminated in the workplace, particularly in relation to reasonable adjustments. I'll touch on um, neurodiversity and dyslexia in the context of education and provision of services because there are equally um, protections and duties that are relevant there, although there's obviously quite a bit of overlap in terms of what that means in relation to the Equality Act. And then, as I sort of mentioned earlier, we will look at, okay, well, you have uh, these things that you're afforded under the law, but what does that mean if somebody doesn't provide that for me, for instance, or you are just outright sort of discriminated against because of your neurodiverse condition. So the Equality Act, as I say, people may be very familiar with this, but I'll give a bit of an overview of what it is. It is the most important piece of legislation and sort of consolidated a lot of other legislation that dealt with discrimination in the UK, and it's been obviously quite well established since 2010. And what it basically means for you is that if you have what's called a protected characteristic, and I'll go into a bit more detail about that in a second, it says that you cannot be treated unfairly or differently if it's related to that protected characteristic. And specifically in the context of what we're talking about today in terms of neurodiversity and dyslexia, that is a protected characteristic. So you can't be discriminated against as a result of that. But there's also lots of other things covered in the Equality Act as well, such as issues like race, sex, religion, and a few others as well. Um, and there's a distinction in the legislation about sort of being directly discriminated against and indirectly discriminated against, and I'll talk briefly about that because I think it is important to understand, because some people might sort of think, oh, somebody's not saying, oh, so being very overt about their discrimination, and therefore that's not discrimination. There are kind of indirect ways that you can be discriminated against, and I think it's very important to be conscious of those because particularly now since the Equality Act has been in place for quite a number of years, you would hope that these incidents of direct discrimination are less, but I'm very aware of the fact that they are still out there, and there are people in particular workplaces who are being directly discriminated against. But what is probably more common is forms of indirect discrimination, where because of the way that a business organizes itself or operates, that they do sort of indirectly discriminate against somebody with a neurodiverse condition, for instance. So just building on that a little bit more, direct discrimination is kind of, as we would expect, and the sort of things that I guess would spring to mind uh, most quickly when you're thinking about discrimination. So where you are treated less favorably because of your neurodiversity. So because you have dyslexia, someone's sort of saying, I don't know, oh, you can't have this because you're dyslexic, or because you're dyslexic, you're going to have to do X, Y, and Z. That's kind of an example of being directly discriminated against. They're telling you, or the reason why they are treating you differently is because of your neurodiversity. Indirect discrimination, as I sort of mentioned, is slightly different. So it tends to be kind of in the policies that organizations might have, or practices in terms of the way they run their business, that obviously apply to everybody. So they aren't saying this is a particular policy for people with dyslexia. But the way that they operate, even though they apply to everybody, puts a disadvantage on you as a neurodiverse individual. So it's important to, as I say, these are the things that probably happen the most because employers or organizations, just aren't thinking about the impact of their policies on certain groups, and particular people that have dyslexia. So, if you are working for an organization and you read one of their policies and you think, actually, the way this works actually puts me at a disadvantage. It might kind of apply to everybody in the organization, but I am particularly impacted by this because of my neurodiversity. And then there's another sort of category of discrimination, which is harassment and victimization. I think this is slightly a more aggravated version of direct discrimination. So this is where, well, somebody is kind of, as it would suggest, harassing you because of your dyslexia. So it might be because they're aware that you're dyslexic, and you have a reasonable adjustment in place in relation to having a little bit extra time to complete tasks, etc. But because of that, they kind of put pressure on you, for instance, or victimization because they're aware that you're dyslexic. They are kind of singling you out in some sort of way, which obviously makes you the victim. And those are hopefully less, but again, very aware of the fact that these are things that do happen in some environments, and it's just worthwhile being aware of the fact that discrimination can take many forms. So, if you are questioning something and saying, well, am I being discriminated against, particularly if you're reading a policy and thinking, this is just unfair to me, then that is a form of discrimination. And again, there are consequences that flow from that, which we will explore in a minute. As I've said, the way that the Equality Act operates is that it says that if you have a protected characteristic, and protected characteristics are a number of things, but obviously for our purposes, things like autism spectrum disorder, ADHD, dyslexia, dyspraxia, all of those are recognized as protected characteristics. So there's two things that kind of flow from that. So because you have one of these neurodiversities, and which is a protected characteristic, you are therefore entitled to reasonable adjustments to assist you with the protected characteristic that you have. So if you have dyslexia, and we'll go into this in a bit more detail, your employer should be making adjustments, reasonable adjustments, to ensure that you are able to do the job at the same level as anybody else, and acknowledging the fact that your neurodiversity might mean that achieving that requires some sort of assistive technology, for instance. And also, as we've kind of touched on previously, you shouldn't be discriminated against either directly or indirectly because of the protected characteristic that you have. So
I just
reasonable
have
adjustment.
a little question.
Yeah,
Do you need a formal diagnosis or anticipatory diagnosis?
you don't need a formal diagnosis to make a request for a reasonable adjustment. I think it is sometimes helpful because the diagnosis might assist you in understanding, and your employer, or understanding what reasonable adjustments might be made. And some employers will say to you that they do need that, but actually they don't. And you can kind of push back on that. But as I say, I think it is helpful to have that in place. I suppose the corollary to that is, what we're talking about initially is kind of, you're in the workplace, you're sort of saying, look, I have dyslexia and I would like a reasonable adjustment. That request, your employer should just say, okay, we understand that you have dyslexia. We'll do an assessment in terms of understanding what it is that you need, kind of like an occupational health type of assessment, and we'll provide some sort of reasonable adjustment for that. Where I think it is important is that if you were to get to a position where they refuse to provide you with reasonable adjustments, having made the request, and you take them to an employment tribunal, for instance, or go through the original ACAS process, and I'll sort of talk about this in a bit more detail as we go forward, then they might at that point try to put you to proof that you did have dyslexia and a protected characteristics. Sorry, and therefore a protected characteristic under the Equality Act. So I think although it isn't a formal requirement when you make the reasonable adjustment, in the event that, say, they didn't provide you with a reasonable adjustment, if you were to then try and challenge them on that, it would be useful to have that diagnosis sort of beforehand. So I suppose there's two bits to it. One is they shouldn't be asking you for it, and you don't necessarily have to give it unless you feel comfortable in giving that. But it is, I think it is useful to have it. Not least because obviously if you don't have it, then you probably don't know. But in any event, it means that if it does go towards litigation, then you're sort of covered in that respect. Does that answer the question?
No, I
I
think
know
that's
that's kind of a bit
perfect.
too.
And real quick, we just had, can you repeat the example you gave of indirect discrimination?
Yeah, of course. So, I mean, indirect discrimination is a bit more sort of complicated to sort of conceptualize in the sense, but let's say that your employer had a policy like a home working policy, for instance. So it applied to all workers across the organization. But the way that the home policy was set out meant that you as a person with dyslexia didn't have the technology, for instance, that would help you sort of do your job in the best way that you can because of this sort of policy. So it applies to everyone. So not everyone's not allowed to have that technology because of the home working. But because of that, you as a person with dyslexia are particularly impacted. Does that make sense? So it is in a position where it applies to absolutely everybody, but only has an impact on people with a protected characteristic, in this case dyslexia, that it will be you'll be indirectly discriminated against. So it's not saying, so it's basically anything other than kind of the direct example where someone's saying, oh, because you have dyslexia, you have to do X or you have to do Y. It's going, well, everybody has to do X and Y, but because of them making you do X and Y, you are discriminated against because that blanket policy doesn't take into account that people will need different things. That's probably a different way to look at it. Anything which is across the board, which doesn't appreciate that there will be different needs in terms of different groups, has a potential of being indirectly discriminatory. Hopefully that
Great,
clear.
thank
Is
you.
that helpful? Happy to sort of go through some more examples as well. I know that can sometimes help expand, sort of make these concepts a bit clearer, because I know I'm very aware of the fact that a lot of these sort of legal concepts sometimes are quite sort of conceptual in nature, and it's not actually until you kind of experience something like, particularly like an indirect discrimination, it might just seem like, oh, well, this just applies to everybody, so how am I being discriminated against? But I think it's just important to kind of understand that what the Equality Act is trying to do is sort of level the playing field, because it's acknowledging the fact that everybody is different, and people with protected characteristics might have needs or things that, reasonable adjustments that might need to be put in place, or things that need to be acknowledged to kind of ensure that there is that level playing field across all of them, and acknowledging that just by applying the same thing to everybody isn't fair. Just because something is the same doesn't mean it's not unfair. But yeah, I'm happy to sort of flesh out some other examples as we go through.
That's great, thank you. We had a couple more questions come in, but I
Mm,
think I'll
yeah.
save them for the question and answer part, maybe at the end.
Okay.
And then I'll let you continue on for right now, and if anything immediate comes up, then we can pause.
Right. Thanks, Grace. Um, So in terms of reasonable adjustments, this is obviously one of the ways in which the Equality Act envisages that people with protected characteristics, and again, sort of particularly in the, obviously what the context of what we're discussing today, how the employer should acknowledge the fact that because you have dyslexia, there may be things that you need to help you do your job in the best way possible. And there is a duty on your employer, and also in the context of service providers to a certain extent. So, if you're accessing sort of public transport and things like that, and educational institutions, so universities, etc., to make those reasonable adjustments. And obviously, the aim of them is to reduce the disadvantages that you might face. So, again, in terms of an example of what that might mean for somebody with dyslexia, it might be a particular piece of IT technology that helps with sort of reading or text, etc., or breaking things down. It might be all manner of things, really, in terms of, and I think it's important to kind of work with your employer to figure out what because also as well, for everybody that has dyslexia, there will be certain things that are more acute, or things that you find more helpful, and by working with your employer to kind of acknowledge and find what those things are, they can obviously best assist you. Because again, like a blanket approach to reasonable adjustments can in itself be discriminatory, because if you're just saying, oh well, you have dyslexia, so you must need this, but actually obviously the way that your dyslexia might manifest itself, together with maybe other neurodiversity, diverse conditions that you might have, or other conditions, might sort of change the dynamic of what the reasonable adjustments are for you. So it should be very personal, and you should work with the employer on that. And as say, ultimately, so this duty is on the employer to provide these reasonable adjustments. I suppose it's just important to kind of note that the word reasonable there is there for a reason. But I think an employer might and will be the one obviously to say that it is unreasonable to provide certain things. But I think it is definitely your prerogative to be able to say, no, actually that is a reasonable thing because of my needs, and it's not completely unreasonable in terms of expense or whatever to do this. And also, it's also worth mentioning that reasonable adjustments can also be things, so not just sort of physical things in terms of a form of technology, or headphones or whatever it might be. It might be in terms of the way that you can run your day, or sort of how much time you have to do things, or those sort of things as well. So they're kind of like practical things as well as physical things as well. And as I say, a failure to make reasonable adjustments, once is it kind of acknowledged that there is a duty on them, is a form of discrimination. Important, I think, to remember as well, and kind of going back to the question that we had earlier on, you're not obliged to tell your employer about your neurodiversity at any point. Employers will often ask that question in the context of, particularly if you're applying for a role, for instance, whether you have a protected characteristic and whether you might need reasonable adjustments for that. And I think it's obviously, prudent at that point to kind of say, well, yeah, I do have a reasonable adjustment, or I do have a protected characteristics and I need a reasonable adjustment. But there isn't any obligation on you to tell them or go into any detail about what that means for you. And actually, it's on your employer to kind of to work with you in terms of figuring out how reasonable adjustments can work. Yeah, and as I've said before, reasonable adjustments can manifest itself in different ways. So policies, working practices, physical layouts, extra equipment. And an important thing to remember, and some employers sort of try on in this respect, that because it's a duty on the employer to provide the reasonable adjustment, they are the ones that should be paying for it, and they shouldn't be asking for you to pay for it. And again, it kind of links back to this reasonableness aspect of it, the employer might say, well, that's unreasonable and therefore you should pay for it. But I think, always drags back to the thing that this is a duty on them as the employer to provide the reasonable adjustment. And it is a reasonable thing that you're asking for. Obviously, if it's something completely, hugely expensive, but all of the things that can help somebody with dyslexia in the workplace are very affordable nowadays and very accessible. So I think it'd be quite difficult for them to say that these things weren't reasonable. So that's what a reasonable adjustment is and kind of what it means in the context, but how do you practically go about requesting it from your employer? And again, I've sort of said before, depending on sort of how you got engaged with an organization in the first place, sort of, you might have at that very initial stage when you're applying for a role, informed them about your neurodiversity, and that's how they'll know. But if not, I think it is, in terms of protecting yourself, there is definitely an advantage in informing your employer that you have a neurodiversity, because it kind of puts them on notice that they then have to do something in terms of reasonable adjustments, if you see what I mean. As I said, there's no obligation to tell them, but by telling them, you are effectively saying, I have a protected characteristic under the Equality Act, and therefore the duty on you to provide reasonable adjustments exists. So if they ever sort of dispute it later on, you can say, well, no, I told you at this point that I had dyslexia, and my request for reasonable adjustments flowed from that, and you did nothing. So it is an important thing to do, I think, to raise it to your employer, because, as I say, that then creates a duty on them. And as we've sort of touched on before, you don't need to have a diagnosis in order to receive reasonable adjustments. But as I mentioned, if it does go to litigation, it is often useful to kind of have that in place beforehand. And I mean, again, the duty is on the employer to provide the reasonable adjustment, but I think it is always helpful if you can work with them to suggest what might be a helpful thing for you, because again, in terms of dyslexia, it is kind of personal to everybody, and so things that might work for other people might not work for you. So as much as there is no clear emphasis on you sort of saying, I need this, that, and the other, sometimes it can just help the process go along, because some employers, depending on the size of your employer as well, just might not be well suited to dealing with making reasonable adjustments. So if you can help them, that's usually quite useful. And as I say, again, worth emphasising the fact that failure for them to provide reasonable adjustments is a form of discrimination. So in terms of sort of the process for employees, so I would, in the first instance, I would talk to your manager or your employer, depending on sort of how that is structured in your organisation, but explain the situation that you're in, and your dyslexia means that certain tasks might be difficult, but those things can be mitigated by having X, Y, and Z in place. And say, have that conversation with your employer about the adjustments that might be necessary, and make sure that this is all in writing. So as I said, if you're informing your employer about your dyslexia, put it in an email, ideally, because what that does is, it creates a paper trail. And again, as this is my sort of lawyer head on, in terms of thinking to the stage where this might not work out properly in your workplace, but the more that you've kind of got evidence in writing of the fact that these things have happened is really helpful, you going forward. And I think it's just an important kind of marker as well, because it kind of, it makes it formal. It makes it that this is, as is appropriate, given the fact that this is a legal duty, something which you can mark back, so you can say, look, I told you on this date that I would need reasonable adjustments, and you haven't done anything in 10 weeks or something like that. That's not appropriate. Just all those sort of things. So I would encourage you to kind of keep a note of, particularly through like an email trail, to show that you've sent it to them. So you obviously given them notice of the fact that you need a reasonable adjustment. Just to kind of take I've sort of mentioned before that there's a point at which you, when you're applying for a job as well, and I think it's important to remember that the obligations under the Equality Act apply equally when you're applying for a job as they are when you're actually in a job. So all through the recruitment process, an employer, will have a duty to make reasonable adjustments. And then if you make them aware of it, and a majority of employers nowadays will kind of ask that question of you when you're applying for a role. But if they don't, and you do need reasonable adjustments to be able to ensure that you're able to complete the interview or any sort of test or anything that might be encompassing the recruitment process, like more time, for instance, then they need to provide that to you. But on the flip side of this, an employer can't ask you if you have any neurodiversity. So they can't say, they can acknowledge the fact that you will need reasonable adjustments, but they can't ask you in an interview, for instance, do you have a neurodiversity? I mean, and that in itself is potentially discriminatory. And also, obviously, gives them, there is a potential there if they kind of identify the fact that you have a neurodiversity and then discriminate or kind of their decision about whether they employ you over somebody else is based on that, then that is clearly discriminatory as well. But that obviously does not preclude the fact that they need to ask you whether you need reasonable adjustments, and they have a duty to provide those reasonable adjustments. So that's the kind of the basis upon which you, as somebody with dyslexia, when you're operating in the workplace, so obviously that initial point where you're kind of looking to be employed by an employer and also kind of in the operation of your day-to-day work, the reasonable adjustment sort of responsibility bites. But what happens if you think you're being discriminated against? And, often that will be where an employer is failing to provide reasonable adjustments. But the first thing to do, I think, is raise it with your employer. And again, do that in writing, do that over an email. So to say, look, you said to me on X date that you were going to give me reasonable adjustments. 10 weeks have passed and you haven't done anything. That amounts to discrimination. What are you going to do about it? If they don't kind of respond, or they respond in a sort of a way that kind of tries to shirk responsibility, then I'd write, or again, put it in writing, but an informal complaint to your employers saying, look, this is now a complaint. 12 weeks have now passed. You haven't given me the reasonable adjustments. This is discrimination. What are you going to do? If that doesn't get you anywhere, then under all, within all organizations, they should have a grievance policy and procedure, which again is like another, I think it's kind of, it will be kind of raising the complaint, the informal complaint that you rose as a formal grievance. So it becomes part of the grievance process within the employer's sort of set of policies, and they will sort of follow or they should follow their grievance process. And if they do, then that's obviously another potential form of discrimination, and also other employment infringements as well. And if you get to the end of, there's no successful outcome through the grievance, then you can bring an employment tribunal claim. On that in a minute. In terms of bringing an employment tribunal claim, obviously this is kind of the last resort and nobody wants to get here, but it is really important to be aware of the tight time scales that are involved with bringing an employment tribunal claim. So I've got on the right-hand side of the screen here a flow chart. So the discriminatory act, that's kind of, well, let's say that they aren't providing the reasonable adjustment, for instance. Now, if they aren't providing a reasonable adjustment, the discriminatory act is kind of ongoing effectively up and until they put in place the reasonable adjustment. So that might be the date, that would be the latest date. But the discriminatory act might also be a moment where they've directly discriminated against you by saying, "Oh, you have to do this because you've got dyslexia," for instance. Now, once you determine that date, and I think it's quite important to kind of get advice about when that date is, because obviously a lot then flows from it. You have 3 months less 1 day within which to kind of raise an ACAS early reconciliation process. And what that does, it kind of stops the clock in terms of the sort of deadline that you need to bring a claim. And that the ACAS process is an attempt to kind of reach some sort of mutual agreement between the parties about how to solve this without going to court. But if that isn't successful, if there isn't any agreement and the parties agree that that's broken down, then you'll get a certificate from ACAS, and then you've got a month to kind of submit your claim to the employment tribunal. So I mean, there's obviously quite a lot there in terms of the timelines, but I think the thing to take away from it is that if you think you are being discriminated against, act quickly. Obviously, if you've gone through the grievance process, I would, probably pretty much, the next day, if it's not content with it, I would go to ACAS. And also kind of, try and seek some legal support, because they'll give you a bit more information about when that date might be. But I think the key thing to take away is act quickly. Just a slide in relation to the education setting. Similar sorts of responsibilities are on schools, colleges and universities. So if you have dyslexia or a neurodiverse condition, which is a protected characteristic, then they have a duty to, in particular, provide reasonable adjustments for you, and also they can't discriminate against you in whatever form it is. Obviously, the reasonable adjustments in the context of education might be slightly different from a work context, but it's the same sort of process in terms of you identifying that you have a neurodiverse condition, which means that you might need these things to assist you, and they can be things like teaching methods, assessments. So you might have more time to complete something, or an assignment might be slightly different because of your neurodiversity. And just I mean, we're sort of focusing mostly on sort of adults here, but it's important just to be aware of the fact that if you've got children with neurodiversities, then obviously there's a whole sort of legal regime in relation to education and healthcare plans, which is a way of a local authority sort of discharging its duty in relation to kind of reasonable adjustments, because obviously that plan will set out what the local authority provides in order to ensure that that child is able to have an education that's on par with their peers. So I've just seen that there's a hand gone up. Happy to take that question. Maybe not. Okay. I'll in terms of, oops. There's also a similar sort of responsibility on service providers as well. So things like healthcare, transport, retail, etc. There are responsibilities on them to provide reasonable adjustments. And that might be things like quiet spaces and public venues, for instance. Bit more difficult, I think, in the context, because it's cannot be always that clear, but it also just be worth being being mindful of the fact that, you know, if you're sort of engaging with a service provider, a public service provider, that, you know, they can equally discriminate against you because of your neurodiversity. So what should you do in terms of compiling evidence and information for a complaint or a claim? I think documents, so everything, you know, all policies, etc., that might link to what it is that the discrimination related. So if it's sort of indirect discrimination through some sort of policy, make sure you're saving. I would make sure you're making your own saved copy of that policy as soon as you kind of identify that it might be discriminatory, because sometimes employers might sort of change it. And so you just want to make sure that you've got a copy where it was obviously very clear that there was some indirect discrimination. Diaries as well, really important to keep a note of kind of behaviour which is discriminatory. So you've got that record, and it's again a really useful tool if you need to go through a grievance or take this through to the employment tribunal. Yeah, keep all the emails that relate to everything that's going on. Just basically keep all the writing and keep everything in writing in terms of how you manage this, because it's a clear sort of paper trail that is then useful if you need to kind of assert your rights in any way. Yeah, think about possible witnesses as well. So if there are people that are kind of observing the discrimination that will support you, potentially just sort of keep them in mind. In terms of assistance, there's lots of sort of template documentation out there on the internet that you can search for, and I'll touch on sort of AI's use of that in a minute. There's some stuff on Dyslexia London in terms of FAQs and things like that, which can be helpful in terms of understanding your rights in this. Legal advice, I know that you know, often, you know, that there are limited options, and particularly if people have limited means, but there are obviously solicitors who can support you, pro bono advice agencies like law centres like the South Westminster Legal Advice Centre that I'm associated with, citizens advice bureaus who can give you sort of a indication of what you might need to do, or whether you have been discriminated against, for instance. And then, you know, I think there's generally lots of online resources, and I'll just touch a little bit on AI, because I think obviously that is becoming an increasingly powerful tool for understanding your legal rights, but I think it just needs to be treated with a bit of caution. So it's really good at kind of explaining legal ideas in sort of plain English, and particularly for people with dyslexia, you know, I find it myself, it's kind of quite good at breaking down text. So if you can find, you know, you can ask it to kind of explain it to you in a way that is best for your neurodiversity. And I think that sometimes is a really useful thing. So if you're trying to understand what a particular, you know, whether the concept of protected characteristics or what a reasonable adjustment is, or kind of maybe a piece of correspondence that your employer has sent to you, then there are lots of really kind of useful AI tools that will help deal with that and then help kind of frame it in the legal context. It's good at kind of providing examples as well, so you can use it as a way of kind of testing ideas. So you can say, oh, I think I'm being discriminated in somebody doing this, and you can have a sort of conversation with it, and it will help sort of tease out some of those ideas. Not to say that then you shouldn't then use that with your, you know, any legal advisor or support that you get, but it's a good way of kind of initially just sort of working through what it is that's going on to you. And I also find it's really good at kind of organizing information such as timelines, particularly if you're looking to kind of figure out, you know, how long you've got to make an employment tribunal claim, for instance, then again, really useful. And it will help you prepare questions if you are going to go and see a lawyer subsequently, or some sort of other advisor. The limitations, I mean, ultimately AI will make mistakes, and has made mistakes. So, you know, just be careful with that. But it is also, you know, has a lot of resources at its fingertips. But I would just always go into it with a mindset, particularly if you're asking it a kind of a very particular legal question, that it might make mistakes, and therefore you need to check it. I might then need to check it with a legal advisor. Yeah, and in terms of sort of drafting legal documentation, you know, it can do that. there are lots of AI tools out there that will sort of draft you claim forms, for instance. But again, it's susceptible to kind of making errors, and I wouldn't take it as read that what it's produced is then going to be perfect, and you need to then sort of test that and check that. So in terms of using AI, I would use it as a learning tool. Really use I'm like good at testing ideas, but I would always double check the sources that it provides, and I would always use a professional advisor with it. So it's like a combination, but it's a really good way because obviously I understand that legal advice is expensive or difficult to get if you're trying to get it free. So it's a good place to start, and then you can focus your attention into a particular thing that then you can go to get legal advice on. And then finally, in terms of like remedies that you can get, so if you go through a claim, you can potentially get compensation if the tribunal finds that somebody's discriminated against you. You can also get recommendations from the tribunal in terms of you're telling your employer that they need to put these reasonable adjustments in place. So both those things are obviously very useful. Won't go into any particular detail on this slide, but there's a range of compensation that you can receive, which will obviously look to compensate you for, the experience that you've had to deal with because of the discrimination. And I'll just put that up to any questions, and thank you very much for listening. I'm just going to quickly plug my laptop in whilst
Yeah,
I
no
do
worries.
wait for questions because it's about to run out of battery.
No worries. I'm going to pull up the questions I sent Chris earlier today because we did have a couple people send in questions in advance. So I want to make sure that we prioritize those real quick while Chris is
Mm.
charging his laptop. Let me. Great. So I think the first question, if we can get to, I will put it in the chat box as well so that
Mhm.
everyone can see it, is, let me, everyone. A lot of companies slash employers either aren't aware of the law or aren't doing enough, according to research from neurodivergent employees. How can companies be best approached regarding this, either verbally or in writing? I guess, yeah, how do you start that conversation if you feel like your
They
company,
aren't doing enough.
yeah.
Well, I mean, I think that, I suppose the basis would be that to just bring their awareness to the Equality Act and say that under the Equality Act, and I'd probably suggest doing this in an email or something. As I said, it's important to kind of have these things written down, and then you can kind of hold people to account on the basis of these things. But it's very well established now, obviously since 2010, and actually before that in terms of other legislation, that there are responsibilities on employers to protect people with protected characteristics, and that dyslexia is a protected, and other neurodiversity is a protected characteristic. So would probably be as blunt and as straightforward as that. This is a legal duty. Parliament has, willed this. This is what they want to happen, and it's on you, employer, to do that. I know that bluntness might seem a bit difficult. It depends on the kind of relationship you have with the employer. But I still think fundamentally, particularly if you're setting it in an email, it's very difficult for an employer to kind of not engage with that, because actually their non-engagement with it can potentially be discriminatory as well. So that's probably would be my suggestion, is just be emboldened by the fact that the legislation supports you in this, and that it puts a duty on the employer. And the more that the employer is aware of that, the better. And actually, you're probably helping them. They may genuinely not know that they had a duty. I would be surprised, and if people do, if they do say that, then more on them. But yeah, I think that would be my advice.
Thank you so much. The second question we have here is, we had another question earlier from Catherine about the access to work
Mm.
process, and I think this kind of covers the same concern. So basically, the the government online application process to apply for access to work is horrendous. It actively disadvantages neurodiverse applicants.
Mm,
Um, Basically, the question goes on to say the average wait time is 6 to 7 months for an initial phone call, who's wholly
mhm,
unacceptable, particularly for individuals who have recently commenced employment and urgently require support. Such delays compromise the effectiveness of access to work.
mhm,
The overall process is disjointed and unfit for purpose. Is the
mhm.
government then failing to meet its legal obligation under the Equality Act of 2010?
It's a great question. And I definitely, the experience that the um, questionnaire sort of cites there in terms of access to justice is obviously a very familiar one to many people, and probably people on this call. And it's incredibly frustrating because that is meant to be obviously one of the mechanisms to provide support to people, and it is failing. And I think there probably is, yeah, potentially that they are failing in their duties, and I'd be interested to know whether any other groups have sort of brought the government to task on this, and they may well have done in terms of writing to them. I'm sure this is something that has been raised with them, and maybe even a sort of a legal challenge in the offing. I suppose, yeah, I mean it's a complicated one because it clearly is something which is not fit for purpose, but is the only sort of um, platform that they can do this. I think just the key thing is just to be persistent with it. Um, Try and find people to speak to within the organizations that kind of run these things, to kind of push these things through. Um, but it is incredibly frustrating, and I sort of know many people that are just kind of banging their heads against walls because of this. And it is really unfortunate. And unfortunately, there's no sort of silver bullet to solve this. But it may be that some sort of challenge or some sort of lobbying from a particular group might help the government get their house in order. But as with many things across sort of public services at the moment, they're just really in a bit of a mess, and it's taking a while to sort these things out.
Great, thank you so much. Another question we had earlier in the chat is talking about does the context of an organization affect what might be considered reasonable adjustments under the Equality Act? For example, does a large company have the same expectations as a startup?
Mm. That's a great question as well. And I mean, it shouldn't make a huge amount of difference, and in particular in relation to what reasonable adjustments you might be asking of in terms of um, dyslexia, because as I say, a lot of the technology is very affordable and accessible, and some of the kind of more day-to-day things in terms of providing more time and things like that are clearly, that doesn't matter what the size of the organization. There may be other things in for other sort of protected characteristics, particular types of physical disabilities, for instance, in terms of infrastructure, that might be more of a case. But I think particularly in relation to dyslexia, there can be little argument, I think, from any type, any size of organization should be able to provide the support that is necessary for someone with dyslexia or neurodiversity.
Great, thank you. Another question we had come up is, let me go back up. You come under. This was a question I responded to privately, but would
Mhm.
reasonable adjustments come under like subjective? An employer might claim they are doing enough when it isn't.
I mean, some employers will definitely try to take a view on what is reasonable for them to provide. Um, and that can often be a dispute between an employer and employee in terms of the employee thinks this is a reasonable thing, they think it's an unreasonable thing, and then those can often be the source of disputes. there's quite a lot of employment tribunal case law now around kind of what things are generally considered to be reasonable in the context of dyslexia, particularly as well. So as I mentioned, actually, unless something is entirely novel in terms of what you're asking for, then there's probably little argument to say that it is not reasonable. If that makes sense. But yeah, no, I mean it is definitely something that employers will try to do if they think that they can make the argument. But I think it's about sort of you can use some of the existing tribunal case laws to kind of support your reasoning in this, and also just generally kind of if you can highlight that it won't have that big an impact. Financially, it's not a big drain on resources or sort of time wise, then it's quite difficult for the employer then to kind of resist that. And again, and if it does go to challenge and you've tried to work with them and show them why it is reasonable, a tribunal will be kind of more supportive of you and less supportive of the employer if they just sort of blanket saying, no, we're not going to do that.
Great, thank you. Another question we had is, I believe this refers to the health field, but can an
Mm,
employee ask for additional time to complete assessments
mhm.
under reasonable adjustments? Does that enable the employee to see the same number of patients as all other staff, or is it okay if they don't?
So if you're working in a medical setting and you're asking, and your reasonable adjustment is to have fewer patients because is that I think is that the question? I mean, I think a
Yes, I
reasonable
believe it's
adjustment.
like not meeting the same numbers of people.
Yes, yeah, yeah. Well, no, of course, because at the end of the day, I guess like the target that has been set is a policy, isn't it? And that policy, if it is applied in a blanket fashion, um, doesn't kind of and may not acknowledge the kind of needs of somebody with dyslexia, could be discriminatory, indirectly discriminatory. And therefore, in order to kind of level that playing field, a reasonable adjustment might be to change the number of appointments that that individual um, sees over their colleagues, because they acknowledge the fact that the reason that that is appropriate is because of their protected characteristics. So yes, in short, I
Great.
mean, again, it might be one of those things that an employer kind of battles with, but I think there's at least, again, if you consider evidence why that is an important thing, and particularly if you're doing it in the context of, well, obviously the patient needs are important as well, and you want to give them as much support as possible. Kind of, I'm sure that would provide more weight to the argument too.
Great, thank you. Another question is, does the law protect against retaliation if I file a complaint?
So if you file a complaint and because of your filing of a complaint, the
I get,
person that you basically get victimized. So yeah, I
yeah.
mean, yeah, 100%. I mean, um, that is kind of victimization or harassment as a result of the claim, which kind of came from your um, rights under the Equality Act. So yeah, absolutely.
And how about, could the delay in access to work applications be countered by an employer paying for the reasonable adjustments, then claiming this back via access to work?
That is a good question. I don't actually know the answer to that in terms of how that would work for the employer. I suppose that would be for the employer would need to engage with the sort of the relevant authority to figure out whether they could do that. In principle, it seems like a logical way around this issue, but I don't know whether that would actually work. Whether that the mechanism would provide for that. So sorry about that.
Great, thank you. Um, and one question is, if writing an email is hard because of dyslexia, can we send recorded requests and do that moreover? What does the law say about sending recordings instead of emails?
Well, I mean, again, sort of, this is a reasonable adjustment request, effectively. So, you would be saying to your employer that a reasonable adjustment for you would be to send recording requests. And I guess it would slightly depend on the nature of the work that you were doing, whether that would be a reasonable thing or not. I can't see why it wouldn't. And again, given that there is lots of technology now that might be able to convert that audio request into a written request, that would seem like quite a reasonable thing in any work context. But yeah, that's the way it would have to be framed um, as a reasonable adjustment request.
Great. Um, Thank you. And Sally, thank you so much for sharing your stories in the chat box. I don't believe they are questions, but correct me at all if I'm wrong. I believe the final question that we have is from Erin, and basically is the response, we haven't done this for other applicants, or this means that we'd be treating you differently from other applicants, a reason to not provide reasonable adjustments. Likewise, the argument of if we did this for you, we'd have to do this for everyone.
But yeah, I mean, unfortunately, this is a sort of a common approach by
Mhm.
some employers, but it's not. It doesn't fly. It can't fly. You know, the whole concept of this is that if you have a protected characteristic, you are entitled to a reasonable adjustment, and if that is something reasonable, then they should do it, and it shouldn't matter whether that then means that they need to apply it to anybody else, um, or that they haven't provided it to anyone else in the past. It is your right to have that reasonable adjustment because you are the one with the protected characteristics. So it doesn't matter about the employer's position.
Great. All right. Well, thank you so much, Chris. I believe we were able to get to most, if not all, the questions from everyone in the chat box, as well as the questions that we had beforehand. So thank you so much for sharing your insight with us and taking the time to give us a refresh with your presentation. Um, yeah, I like every webinar, we will circulate the recording of this. So hopefully that will be helpful for everyone as well, to come back. Great. Thank you all. And thank you so much, Chris.
Thank you very much. Nice to speak to you all.
Thank you all. All right. We'll be in touch. Have a good one. Bye.